Yes, good evening. Welcome to MCAT. Today is November 2nd. With us today, we have the candidates for the Justice of the Peace. It's going to be an hour-long program, and if you'd like to call in, our number here is 542-6228. Got some simple guidelines. We're going to ask the callers when they call in that their calls be concise, and we'll ask the gentleman here that we'll have them finish their answers before anybody else kind of comes in. And we'd like to start this off with a 3 to 5 minute introduction and whatever else you guys want to talk about. We'll start with John Olin here first.
My name is John Odlin, running for Justice of the Peace against David Clark, the incumbent. Been a Montana Highway Patrolman for 23 years, married for 28 years. Have 2 sons, and worked here in the Missoula area now for about 17 years. I feel that I qualified for the job because of my law enforcement background and because of my workings with the court and with the county attorney's office. I believe that I can bring a better working relationship between all law enforcement and the prosecutor's office to the court system, and more continuity as far as maintaining help in the court system. I feel there's a lot of issues that need to be worked on in the justice race, such as the DUIs, following through with DUI prosecutions, make sure that those things are handled completely, and that repeat offenders get serious with repeat offenders. I also believe that we need to do something with our warrant program that's currently going on. It's costing the taxpayers an awful lot of money for warrants to get these people transported back to Missoula, and then to have them be turned loose again and told to be back in another couple of weeks with the amount of money that they are to pay for their traffic violations and not doing any jail time after repeated offenses. I think that I can do a good job with that. I think because of my law enforcement background, I have to take that hat off to be the Justice of the Peace. But I think with my law enforcement background and my training as to being trained as an accident investigator, radar operation, gas chromatograph operation, or intoxilizer, if you will, that when somebody comes into court, that it's going to have to be a good case to get a conviction on either side, whether it be the prosecution side or the defense side. And I think that all of those things qualify me for the job. I realize that I have some weaknesses in the civil side, and I believe that I can learn that. The past justices of the peace have to learn everything, including the traffic offenses, when they come into the job, and I think I've got a leg up on that. So for those reasons, I believe that I would be the candidate for the job.
David Clark.
My name is David Clark. Excuse me. I'm a Justice of the Peace then for Missoula County in Department 1. I've held that position since 1985. Justice courts, between the two, there are 2 justice court departments. And between the 2 departments, we handle in excess of 20,000 cases a year. And as you can see, that means that justice courts are extremely busy. Nonetheless, it seems to me that justice courts, even given that fact, are one of the best kept secrets around. And so what I'd like to do is just utilize the time in my introductory comments to explain just very briefly what the justice courts are about. And the kinds of cases, of course, that are handled in justice court are divided principally into 2 areas, criminal and civil. And in the case of the criminal area, then again there's a subdivision into the areas of felony and misdemeanor. Now, a justice court is not the trial court for felony cases, but felony cases do come through for an initial appearance in the justice court. And the purpose of that appearance in justice court is for the setting bond, determining the appropriate amount of bond, and also explaining individuals' rights, making certain that people have access then to an attorney and that an attorney can be appointed by the court if necessary, and then to consider, of course, the conditions of release on bail should they be held on bail. The cases are then turned over to the district court for further prosecution. On the misdemeanor side, justice court is the trial court for all misdemeanor cases prosecuted through the county. And misdemeanor cases are very wide-ranging. They cover, for instance, fish and game violations. They cover violations of city-county dog ordinance, of the pollution ordinance as well. traffic, of course, and also matters that people would normally associate with misdemeanor offenses, such as theft, domestic abuse, assault, and the like. On the civil side, Justice Court has a small claims division, and in the small claims division, the jurisdiction of the court is up to $3,000. And there are some procedural differences between the two courts, that is, between the small claims division and the regular civil division of the court. But nonetheless, the subject matter is principally the same. But on the civil side, the court's jurisdiction is up to $5,000, although it's an unlimited monetary amount in landlord-tenant cases. And we do see a lot of landlord-tenant cases, a lot of negligence actions, and a lot of contract violation cases brought before the court. The cases, that we see are sometimes fascinating. They're sometimes very frustrating to deal with, sometimes very rewarding to deal with. They're always very intriguing, very interesting. I enjoy the job a lot. I think I do it well. My opponent here has raised some issues, and I'll leave it to you folks then to ask questions about those issues or of anything else that might come up. I'll be happy to answer your questions. Thank you.
And the opponent in Department 2, Dan Poe Newman. Go ahead.
Hi, good to meet you. If this is the first time, if I've been to your house, you know me. You know after talking to me for just a few minutes where I stand on most of the issues. I'm a reform candidate, trained in law, trained in investigation, trained in nursing, as a matter of fact, while I was working my way through law school and college. I have a great deal of experience with dealing with people, finding out fact from fiction, finding out what's important and what's not, and basically trying to reach a reasoned conclusion at the end of the trial instead of at the beginning. My opponent, Michael Morris, chooses not to show. We don't have much of a debate going here. I'm going to enjoy listening to the other two judicial candidates. Hopefully, you're not watching the Channel 8 KPAX debates, which were pre-recorded and moved to 7 o'clock. Whether or not that was to take emphasis off this quite heated race and quite heated races, I don't know. But I do know one thing, and that's very few people out there that I haven't talked to personally know that there is a contest with Michael Morris and myself completely on opposite sides of the issue of reform, cleanup, and Dusty Deschamps. These are my comments right now.
Thank you, gentlemen. And Michael Morris was not able to be here, but we do have a brief comment from him, and it says, "Please accept my regrets that I am unable to be present for the program on November 2nd, 1994. I have prior commitment in Bozeman to teach a class on DUI laws for the Montana Highway Traffic Safety Division. I was appointed to the office of Missoula County Justice of the Peace, Department 2 in September of '85. I ran for office and was subsequently reelected in both 1986 and 1990. My priorities in this position are to follow the law and to serve as a fair and impartial judge. While there are many cases, I have worked hard to listen carefully to each person who comes into the court. I maintain active involvement in the community. And for example, I'm a member of the Missoula Family Violence Council and the State DUI Task Force. In addition, I'm a regular speaker at local high schools, Leadership Missoula, and the University of Montana Law School. I consider it a great honor to serve the citizens of Missoula County as Justice of the Peace." Signed, Michael D. Morris, Department 2. And if anybody has a call I'd like to ask our candidates here, the number is 542-6228, and you can call and ask questions. Now, with the legislative session coming up, there's been some talk about a law of 3 strikes and you're out. I wonder if I could get some comments on what you think, Keith Leanhout's, Okay, with the 3 strikes you're allowed, I guess what they're saying is with us putting so many people in prisons that we'll have to build new jails every 3 years. What is your opinion on that? We'll start with Dan. About 3 strikes you're out, and will it work on certain cases?
I have great difficulties with taking away any form of discretion either from the police or from the judges in the courts. I believe in a three-part system of government. The legislature can enter into the courts by making mandatory sentences, by introducing legislation such as 3 strikes you're out. I like to think of myself as a liberal with teeth. I don't back away from any words, whether they're charged or can't be construed as seeming as somebody lenient. As Wally Clark did long ago, I would tend to conduct court in a relaxed and informal manner as much as possible. 3 strikes and you're out, any kind of rigidity would have to be, in order to be constitutional, would have to be adequately spelled out as to nonviolent, violent offenders, persons in violations of law, malum prohibita, malum in se, wrong because they are simply wrong violations of the law, wrong because they are statutory, and this is what society says right now to be the case. 3 strikes and you're out seems to me unduly rigid and constraining to the judge. I do not. You can be either very good or very bad, but discretion is mandatory in a judge.
David?
I've not read that legislation. Perhaps you could describe it in a bit more detail for us. I'm hesitant to comment on something that I've not looked at. I'm familiar with the concept, but for instance, do you know whether the law applies, for instance, only to felony cases?
Well, I think it was a statement made by the corrections officer in Helena that said sometime during the next legislative session that this legislation might come up, and it was his argument that if it did come up, that we'd be building more jails because we'd be putting, like, bad check writers and those kinds of people in prison for 3 offenses, and that it would cost the state a lot more money, and we'd have to find other alternatives to house these people.
Well, I think that's certainly true. We would have to build, prisons to accommodate those who were sentenced if such a rigid law were introduced. I don't think that the law is going to pass. I think that there's too many practical difficulties with it on the one hand, and people, I think, recognize that depending on the offense, sometimes prison isn't the best alternative, and certainly the judges would need firm guideline, that is, would need to have considerable discretion with respect to how much prison time should be mandated or at least imposed from the bench in order to address constitutional problems that would crop up with prison overcrowding. I think the legislation itself, even though it has not been, it's not achieved its formulation as yet, certainly stems from a valid concern. And that concern is, how in the world are we going to keep criminals off the streets? And it's an age-old problem. It's certainly, the cliche is that it doesn't matter how many prisons you have or how big you build them, because as soon as you fill them up, as soon as they're built, they're going to be full. There's a certain flaw in that logic, because it tends to suggest that since we can fill our prisons, that we shouldn't enlarge them. I don't think that that's correct, and I do think that we need to be able to we should have available to us measures to keep people off the streets who need to be off the streets, but to legislate exactly who needs to be off the streets, I think, is a mistake, and I think that judges ought to retain that discretion and look at the cases individually.
Yeah.
I think that we're talking about something that's above the JP level. We're talking about something from district court, and I think those cases have to be handled by district court. And we're talking about serious felonies, and I have not read the law either. I do not know for sure what is in there. I've seen the National Crime Bill, and it was heavy-duty drug dealing, murder in certain cases, felonies that were committed against federal officers and police officers. Those were the types of things in that particular bill that were going to be 3 strikes, you're out. But as far as the state bill is concerned, I'm not sure exactly what is named there. And yes, it may cause the prisons to expand, but I think the public is going to have to make up their minds sooner or later what they're going to do, whether they're going to let these people walk or if they're going to put them away.
I guess we have a call here. On line 1, you're on the air. Oops. Line 2.
Good evening. I'd like to make a comment about this concept of 3 strikes and you're out. On the one hand, it is, as one gentleman did say a moment ago, a highly restrictive concept, but yet at the same time, it can be argued on the other side that 3 strikes and you're out if we're dealing with felony child abuse, for instance. Are we going to allow a child abuser to get 3 shots at staying out of prison for life?
Well, do you have a question?
Absolutely. I'm wondering exactly how this concept can be worked at all, and because it is, as was stated earlier, removing all discretion from judges in each individual case. Because is that not how our Constitution is structured? That we gain individual justice, and not a. Yes, understandably, the public has at large has a say and a right to say how they feel and how things should be handled. This is true, the majority, but we are still a nation, I believe, of individual justice, are we not?
Well,
I'll hang up and I'll listen to your response. I appreciate your time and have a good evening.
Okay, thank you. I think what he's saying is that I guess judges do have, or should have the discretion, as David said, on those kinds of matters to determine the 3 strikes rule. Any comments?
There's just a lot to think through. As I said earlier, and I think we all agree that the concern that underlies the bill is a real and a valid concern. It's the same concern, for instance, that people have tried to address with gun control laws. And much of the problem is often, not gun control itself, whether that's a good thing, but how to make something like that work, and how to find a way to make people more responsible, and to find reasonable means of restricting people's access to guns. In the case of this crime bill, which is being contemplated, certainly there are just too many things that need to be thought through that haven't been thought through yet. At least in some arenas, and those have to do with the wide variety of types of crimes that might be committed, and also the various levels, as we've also discussed, between just pure misdemeanor and felony offenses. And of course, one cannot achieve anything like justice in an individual case if one's fate is decided in advance by legislation, and that's really a key factor here, and the main reason why I think such a law is ill-conceived.
I'd like to respond, John.
I still feel that we're talking about something that is handled up in the district court level. JP Court is not going to get involved with it. I don't think we're going to be doing 3 strikes, you're out with misdemeanors that we're handling in the Justice Court, and I just don't believe that we should be involved in it. I mean, sure, it's something that's going to happen. It's something that's being talked about, but as far as this race and this debate, I don't think that we're involved with it.
I'd like to ask John here, when you ran during the primaries, you stated that one of your main complaints and the reason why you ran is that Justice Clark doesn't try to take into account your schedules and your workloads, and of course you mentioned you were unhappy about the picking up people on warrants when they don't pay and stuff. Do you still feel that way?
Yes, I do. I feel strongly about that. I feel that that the officer on the street has made the commitment to issuing the citation or the charge, or there's some reason why that this person is coming to court. The Justice of the Peace is 8 to 5 Monday through Friday. The prosecuting attorney is 8 to 5 Monday through Friday, and so is the defense attorney. So now we come down to the defendant and to the officer involved. And I believe that we have to try to work with that officer in that so that he doesn't have to give up his days off. He doesn't have to give up his time off to go to trial over something that he has got involved with because of doing his job. And I think that can be worked with. I know that there's bigger places than Missoula, bigger places than Missoula County that work with it every day, and they handle it very fairly. As far as the warrant issue is concerned, I'm still upset about the fact that the warrants are issued, and we issue a warrant and we go out and pick this person up. Myself or one of the officers pick this person up, we bring him in and put him in the county jail. The judge has discretion, I understand that, but when it's 3, 4, 5 times for the same person, for the same amount of bond, and nothing is done about this, I think it's wrong. I think we're wasting taxpayers' money. I think we're wasting time of the officers, whether it be highway patrol, city police, or county sheriff's officers. I think we're wasting their time picking this person up over and over and over again. And it's making a mockery of the system in that they say, well, if I'm going back up before the judge again, I'll beat you out of the courthouse. And I think that's wrong. I just think it's wrong. I think it's the wrong attitude that people have, and I think that we need to correct that.
David Clark?
All right, thank you. Well, first of all, there are a number of misconceptions underfoot already. Certainly a justice of the peace job is not an 8-to-5 job. That is, it's a very demanding schedule. It goes well beyond 5 o'clock many nights. Also, weekend duty is regularly scheduled in. And for instance, I have a trial tomorrow morning that I have not prepared for. You might think that, well, that's a bit and that I'm going to have to prepare for after this session tonight is concluded. You might think that that's a bit strange, for instance, for a judge to have to prepare for a trial. But as a matter of fact, if you want to do your job well, you'd better be prepared, because I think a judge has, as part of his responsibility, the right, an obligation to set some standards of performance and to expect that people will prepare their cases well, and that the interests of the state, for instance, don't get frittered away because of poor preparation, or and similarly for the defense. I think that there are ways, techniques available that we can talk about if you like, but to encourage this kind of preparation. And certainly this preparation means being fully informed with respect to the issues of the case, and also to the kinds of circumstances and controversies that might arise within the context of the trial itself. And so, for instance, in pretrial conferences that are held not only in civil cases but in criminal cases, it is my intent to inform myself of what those issues are likely to be, so that I can be prepared, so that I do not have to make off-the-cuff decisions or rulings when these matters come up then before the court. You know, getting blindsided by these questions is just a way of, it just sets yourself up for making bad decisions. I don't want to make bad decisions. I want people to be prepared, and I expect that of myself. In terms of the matter of warrants, I think, again, John has raised I'm sorry, I've forgotten one issue, and that was the schedule of the officers. See, that again is a mistake. It's the responsibility of the court to treat people fairly and even-handedly. No one has a special interest or access to the court. That includes law enforcement officers. Law enforcement officers do not have the right to come up, for instance, and chat with the JP, the judge, about cases that are going to be coming up or about people they've written tickets for, and expect to be able to bend the judge's ear about these cases before they come to court. And that kind of access, for instance, as well as the kind of consideration that would come into play by giving officers special interest, by taking their schedules into accommodation when the court, of course, cannot take other people's schedules into account, is special treatment. And no one is entitled to that. There's an even-handed way, as I said earlier, to treat these matters. If there is a scheduling conflict that an officer or any other litigant has with respect to a court date, then the person who is trying the case, the defense attorney, for instance, or the attorney in the civil case, or the prosecuting attorney has the right to ask for a continuance. And this is a formal procedure, to ask for a continuance and to see whether or not the interests of the parties are affected by having the court grant a continuance. And if it's not adverse to the interests of the parties, I'm going to want to grant that continuance whenever it's reasonable to do so. One of the factors that's under consideration here is also moving the cases along. Just because officers, for instance, have a vacation schedule does not mean that cases need to be set back on the schedule time and time again. Cases need to be moved along so that they can be timely heard and disposed of. Court delay is one of the, and the difficulty of managing one's calendars is one of the biggest challenges that any judge faces. Going to the issue of warrants. It's true that sometimes when people come in, and John is talking mainly about traffic cases here, and the kinds of cases we handle are much more wide-ranging than that, but still, it's true that even in traffic cases, sometimes people don't pay their fines. And what's the best way to handle that when somebody does not pay their fine? It may be that a warrant for their arrest will be needed in order to get them in and encourage them to pay that fine. We try to bypass and make this whole system as efficient as possible by, first of all, as I said, bypassing law enforcement by we actually send out computer-generated warnings to these people, letting them know, look, you got 5 days to come here, take care of this, otherwise a warrant will be issued. If they don't come in, then the warrant's issued. Now, most of these people that this happens on are not arrested, but some are. And when they are arrested, then they're faced with contempt of court charges. And if they are in contempt, they often spend time in jail even the first time around. Certainly, the second time around, they're going to spend time in jail. It doesn't mean that I'm going to ask them that I'm going to order them to serve out a $300 fine or a $500 fine at $25 a day. That's, on the one hand, I think simply too harsh. And at the second hand, and on the other hand, it's a mistake for other reasons. One, it costs the county money to put people in jail. When people are in jail, it costs the county $40 a day to keep them there, to have the personnel and to have them fed. Secondly, if people are serving out their fines instead of paying them, then of course the county is not getting the money that it otherwise would get. It's an officer's duty and responsibility to serve these warrants, and they do not serve them 5 times. However, but when a person is brought in on a warrant, if they do not have a valid excuse, they then may be held in contempt. They may spend time in jail. Certainly a second time around, they will spend time in jail. They're looking then at serving it out in all probability on a third arrest, or at least on a third warrant. But even then, sometimes circumstances need to be taken into account to see if it's realistic, for instance, to give it one more shot. But again, that's depends on the individual idiosyncrasies of the case. And that's what we have to look at.
Okay, I think we do have a call here, so let me go to line 1. Hello, you're on MCAT.
Yeah, I was just wondering that some of the credentials of these candidates here. I must have missed it maybe.
Oops, they turned on your TV, I think.
All right.
Would probably help out. Or you get it down?
Yep. I was just wondering the credentials of these candidates. I don't know if you had them on earlier, but I missed, and I was just wondering what they were.
Yeah, we could probably go over that again. I mean,
Did you say them already? That's fine.
so that's fine, because I mean, most people would think that you'd have to be a lawyer and go to law school to become justice of the peace. Because in the courthouse, why don't you start off, Dan? And
Yeah, Dan Poe Newman, a graduate of Cal State Long Beach with a BA in political science. Graduate of Western State University College of Law, Orange County, that's in California, where I got my JD. I've worked as an investigator for attorneys. I've worked as a law clerk for a total of 6 years. Never passed the bar, took the bar in Montana in 1986, along with 3 of my classmates from Western State. None of them passed. Pass rate's over 90%. I decided to write, and I've been writing since.
Jeff Clark?
My qualifications, I think, fall mainly within 3 areas. One, well, I'll put it this way, my background, I have a background in construction work, and both as a worker, I was a cement mason for a number of years. I've worked in Montana, some in California, a bit in Indiana, but mainly here. And I was also then owner of a construction business for 4 years, concrete contracting business. And on the academic side, I have a BA in philosophy from the University of Montana. I have a PhD in philosophy from Purdue University. I was, at the time at which I was appointed to this job, running the construction business as well as teaching philosophy and humanities at the University of Montana on a part-time basis. And when I took this job, which was in August 5th, 1985, that's what I was doing when I was appointed by the county commissioners. The rest of my background qualifications then come in the training that I've received, formal training that I've received at the National Judicial Institute since I've held this position, and also in the semi-annual training sessions that we have here in Montana, and also considerable overload on on-the-job training in 9.5 years as Justice of the Peace.
As I stated before, I have 23 years in law enforcement. I am certified in the operation of radar. I am an expert in accident investigation. I can run the intoxilizer. I can do everything that is needed to be done to be a police officer or a highway patrolman in the state of Montana. And I think these things are unique qualifications for me as far as starting out in this job in Justice of the Peace, in that I know what it takes to make a case. I know what has to be done. I know what the right steps are, what has to be done, such as in a radar case. I know the steps that have to be there to make that case. The same as accident investigation. I know what it takes to make an accident investigation as far as proving a citation. Along with working for the Highway Patrol, I also worked in gross vehicle weight, which is now called Motor Carrier Services, which is for truck size and weight and dimension. I also am a certified truck inspector for the state of Montana under the MIXAP program, so that I know trucks, I guess you could say, inside and out as far as the mechanics and whether or not they're safe or not, logbooks that are required for trucking. I also have worked in construction before my time with the Highway Patrol, and I also was an assistant manager of a shoe store here in Missoula prior to my work with the Highway Patrol.
All right, I think that answers the caller's questions anyway. And if you'd like to call in with your questions to one of the specific candidates, you can call 542-6228. There was a judicial study in 1988, and Judge Green at that time was a part of that task force, and he recommended the use of in-home electronic monitoring. Is the justice courts and the police set up to do that kind of stuff here in Missoula? And would that alleviate some of the overcrowding and cost associated with prison time? So let John start off with that.
I'm going to be perfectly honest. I don't know whether the Justice Court is set up to do that or not. I know that there is some in-house electronic things going on with probation and parole, but I'm not sure about whether it's used in Justice Court or not. I would think that it would have an impact on reducing some of the jail time that is spent that could be used, but it also requires close supervision to run those electronic devices. I know that with adult probation and parole, they spend a lot of time checking on those people to make sure that they are still at home.
David?
Yeah, we are set up to do it, and that's mainly because there are several independent programs around that specialize in just those kinds of activities and supervision. And when it seems appropriate then to utilize that supervision, then these people are contacted, and the in-house incarceration or home arrest is then set up and monitored. It's not something that I use very often. It's a good device. I think it's something that has, and this is fairly obvious, I think that it would have more effective utilization at the felony level, but there are some good usages of it at the justice court level for misdemeanor offenses. In particular, one of those instances is for concerns conditions of release on bail, so that a person's whereabouts might be monitored, for instance, in a domestic abuse case where there's a high concern that this person not have contact with the alleged victim while the case is pending. Or, for instance, where you've got a multiple alcohol offender, one of his conditions, there's a multiple offender for alcohol-related offenses, where one of the conditions of his or her release on bail is that they not consume alcohol. And there are ways then of providing periodic checks as to whether or not this person is in fact consuming alcohol. In terms of the utilization of in-house arrest as a substitute for jail time, it's something that I use very seldom. When I think a person needs to go to jail, it's my position that he needs to go to jail and not be under house arrest. House arrest sounds harsh because it, in fact, is an arrest. But still, in the eyes of some people would like nothing better than to be shut up in their house for a few days and be left alone. It's, in some cases, just not appropriate punishment, and where incarceration does need to be utilized to send a message, they go to jail.
All right, Dan?
My ultimate concern is not with punishment. It's not even so much with justice. It's with recidivism, crimes, and people hurting people. That is my ultimate concern. And I would have to study in-home arrests and in-home supervision to find out not only whether it's cost-effective, but whether it helps determine best whether this person is going to be a recidivist, whether he's trustworthy, and how the person conducts themselves under this type of supervision before I can answer any more fully. I can't emphasize enough that no one should be above the law, and that the punishment, where applicable, should fit the crime. You have violent offenders, you have nonviolent offenders, you have drug offenders, you have all sorts of offenders, traffic, chronic traffic offenders that continually get in trouble with traffic. Eventually, you have to be harsh with them, sometimes very soon after the first offense in the case of DUIs. But what I'm looking at basically is this person safe to be in the neighborhood, to be in the city, to be in the county? And within reason, I don't see making it any more easy for this person to commit a crime if he's been determined to have committed a crime. The main priority is to keep him away from other people, and I don't see in-home particularly as doing that.
It's been stated that, I know in the news recently we've seen an upswing of sex offenders around Montana and Valley and Missoula County, and that they account for about 34% of the prison populations. And even though their average stay is 35 months, and they should be there about 60, what can we do to rehabilitate these people, and how can we make other offenders of violent crime and those kind of things to where they actually serve their prison time? Dan?
Well, I don't want to duck and say at the justice court level you simply hear whether probable cause is sufficient to remand them on to trial. There are misdemeanor offenses. The judge can better say whether there are felony offenses that are covered in justice court with a guilty plea, perhaps. My basic feeling is that as far as rehabilitation, you have to make a sharp determination in the beginning whether sufficient probable cause exists for this person to be held. A person does have rights. Where there is evidence of a crime and where there is, it's most likely that this person committed that crime, the district court will handle that, generally.
David?
Well, again, John mentioned earlier that with respect to one of the questions, that this is not something that had immediate implications for justice court, and I think that this is another one of those questions. However, it's a good question, and I'm happy to answer it. I think it's true that, for instance, in justice court, we certainly don't see, there are very few sexual offense cases that are prosecuted at the misdemeanor level. Occasionally there's one, there'll be one or two, but most of those are prosecuted at the felony level. And then with respect to the question of, well, what should we best do with these people? Should we be keeping them in prison longer? And how can we best rehabilitate these, these individuals if they are convicted? That's a tough question, and it's one that people have been wrestling with in a variety of research organizations for a number of years. And the current wisdom, and certainly there is, and I say that quote unquote, certainly there are differing views, but the current wisdom seems to be that for the most part, many of these people are not good candidates for rehabilitation. And there's, in many of these cases, that's true for several reasons, but not the least of which is that the criminal behavior in general is such that once it establishes a long-term pattern, that is a firm criminal history in which one's values and behavioral trends are set, in order to suppose that we could, turn this around, transform it, so to speak, from the ground up by a few counseling sessions undertaken in prison, is just a bad mistake. It just does not happen, and the recidivism rate attests to this.
As David said, again, JP Court does not handle these cases. We are not involved. We're involved with the preliminaries where we see them to begin with, and I don't know what the studies are as far as the parole rates or what the months of stay in prison are, because it's above what we are handling. And I just, I'm not going to comment any further on it.
Okay, we do have a couple of calls. Let's go to line one. Hello, you're on MCAT.
Hello?
Yes.
I would like to pose a question to Judge Clark, please.
Go ahead.
Is this Judge Clark?
Yes, it is.
Say, Judge Clark, I was wondering why you've had so much of a turnover in employees under your office, under your authority, and could you give several reasons for these such turnover in your employees? Now, I'll hang up and wait for your answer. Thank you.
Thank you.
All right, well, the answer is actually, to be understood, a complex answer. One, going back now some years, it was my perception, and it is still my perception, that at one point in justice court there were some very severe performance problems with respect to our ability to protect the rights and interests of people. And there were a number of problems, for instance, with warrants being served that shouldn't have been served, and related difficulties. I'm not going to go into any more detail there, but these are matters that are of extreme importance, and they needed to be addressed and looked at with some care. I then undertook measures to do that. And in undertaking measures to do that, I needed to change, it became evident, the status quo, and with respect to the way things were going to be done around the office. And that challenge of attempting to change that ultimately culminated in a lawsuit with the county commissioners in order to protect the court's right and obligation to make certain that the affairs of the court were properly run. And the ultimate position here, of course, is that it is not, for instance, the county commissioners or any member of the executive branch, nor is it the staff, that of the staff members themselves, to decide what ultimately is in the best interest of the court and how it should be run and how the people's interests are in fact best protected. That responsibility falls squarely on the shoulders of the judge, and that was me. Now, once the district court reached its decision, which was later overturned in part, but once the district court reached its decision, then the clerks who had been working under me left. And subsequently, I hired new staff. It was very difficult then in hiring the new staff for those staff members to work in a situation that was very emotionally charged. And that emotionally charged situation was coming from various sections of the courthouse and directed at me because of my attempts then to improve the matters within the internal workings of the court. It reached the point where some of my staff members quit because of that stress. They did not quit because of me, and they quit because of difficulties of getting along with other people in the courthouse, the way they were treated, and their inability to work effectively with other agencies in the courthouse. This is summed up very nicely in a letter by it was written by Nancy Anderson, who was my office manager then during part of this time, and chronicles in some detail and with some graphic impact what this treatment was like. Since that time, she was then part of a group of people then that quit, and since that time, well, during that time also there was a termination because there was a performance problem at one of the seats. Since that time, hired all new staff, and they're very happy, very dedicated, very intelligent. They're weathering the flak very well. Everyone is happy, working well together, and we have made decisive strides not only in the right direction, but we're in fact where we need to be.
Okay, we've got a call line too, so why don't we go ahead and we'll go there. Hello, you're on MCAT.
Thank you very much. Good evening. I was just listening to this informationally, and once I heard the response on the construction background in preparation for judgeship as opposed to law enforcement, I had to give a call because I remember back in the primaries that there was some intensive radio advertising that was, well, against Judge Clark, and I don't know if he elaborated on that just now or not with regard to why they were doing this radio advertising, but I'm real curious on what was resolved with that, and if anything, what did it cost the taxpayers of Missoula for this?
And what kind of advertising was it, or do you remember the specifics of it?
It was strictly anti-Judge Clark advertising during the primary.
Okay, have you heard that, John? Or I don't remember.
This was back in the primary. There was a group of individuals, and I believe they were employees of at the courthouse under the supervision of Judge Clark that were doing these advertisements with regard to anti-Judge Clark.
Maybe David could elaborate on that, probably. But
Well, I'm not exactly sure what the question is.
Well, the question precisely is, what is the substance behind those? What was the impetus behind that? Why were they doing those things?
Well, I think you've answered most of that.
Yeah, I've tried to answer that in some regard.
The other portion of that question is,
Go ahead.
it's, of course, a lot of this was in the paper, a lot of it was rumor, and I guess we want to hear it from the horse's mouth, so to speak, on what did it cost the taxpayers, myself and others, in terms of any litigation or anything along those lines, and what became of those individuals that are no longer under that employment.
Okay, thank you.
Okay, I don't know, I'll start with the last question first. I don't know where all of these individuals are. I think all of them except one are still working for the county. And I'm virtually certain that that's the case. So they've gone elsewhere within the county with all but one exception. The group itself, now that did that advertising, that's an interesting matter in and of itself. They call themselves on the disclaimer previous employees against Judge Clark or something like that. Previous employees against Judge Clark. And I think Paula Stinger is the name of the person then who's referenced as the treasurer of that particular committee. It's a political action committee, and it's designed then to influence an election. And one of the interesting things about that has been brought to my attention, I was not aware of this until recently, but one of the interesting things about that is that any political action committee is required, of course, to file a report and to list. They've obviously spent a fair amount of money, both in the primary and in a couple of recent ads that have been taken out in the Missoula. So they're required, to make full disclosure here and to register both of the county and the state. It's been brought to my attention that that has not been done, and that the reports as to who actually are participating in this committee, they're just not available. And so we don't know who's doing it. It's illegal, of course, to advertise in that way, and it is subject to prosecution. And I don't know, I have no interest in doing that, but at the same time, those seem to be the facts, and I don't know who really is, since these reports have not been filed, I really don't know who really is involved in it. In terms of answering your question about what the lawsuit cost, I don't know what the lawsuit cost. I can tell you that, first of all, I want to give you the upshot of the Supreme Court decision, and I'll be very brief about that. But basically what the Supreme Court decision said in overturning Judge Harkin's decision was that before the court can assert its authority, for instance, over the rulings of an executive branch such as county government, which might try to control the court's employees, one more procedural step than the one I actually took, needed to be taken, and that was to go through a grievance hearing. And all other procedural steps were followed to the letter, and that was never in dispute. But when it got to the grievance hearing, since the decision of the grievance hearing was going to be either consistent with mine or inconsistent with it, then or consistent with that of the judges. All other jurisdictions who have looked at this question have decided that the grievance hearing itself, that process is unconstitutional. Now, the Montana Supreme Court disagreed and then said, and I'll just sum up again, that before the court could assert its authority there, the last step, going through the grievance hearing, did need to be taken, and that is now the law in Montana.
We're getting short on time. But
oh, well, all right, I'll stop then if you like.
I want to get in one quick question here before we go into some closing statements. And the fact that we have a lot of repeat offenders for DUIs, I know John has brought this up in his literature, how can we, and if you can give me some short answers, how can we deal with that problem? And I'll start with John.
I think that we have to be firm. I think on a first offense, anyone can make a mistake. But I think that after the first offense, and it continues to happen, I think we have to take firm measures, whether it be fine, counseling that's required, and whether it has to be jail time. I think that these people have to be made aware of the fact that this is unacceptable behavior. DUI behind the wheel of a car is just like going out and loading a gun and handing it to somebody and say, here, going out, shoot somebody. It's basically the same thing. It's a loaded weapon going down the road, and it can kill somebody just as fast as a gun can. And I think that we need to be firm with these people, and I think we need to get their attention, so to speak, and to change their attitudes so that we don't have a recurring problem.
David?
Okay, I agree completely. And everybody knows what a lethal problem DUIs are and what a danger they pose to citizens and to people who use the roadway. DUI cases are not treated leniently by myself. Anyone who is familiar with my court knows that. I think that in the case of repeat offenders, it's necessary to enhance the penalties in accordance with the provisions of state law. I routinely do that and look to the merits of the case, in particular the merits, and also look to issues in every case regarding whether any sort of restitution might be appropriate as well. And often that's something that tends to be overlooked unless the judge is aggressive in trying to pursue the interests of those involved. But I fully agree, DUI cases are a big problem and they need to be treated accordingly.
Okay, Dan?
Yeah, DUI, no patience, no hospitalization for that matter, and no morgues. I don't see that there's any difference in any of the four candidates, and I have to speak for my opponent on this, as to DUIs. You can't have any patience with it whatsoever. You see something going on for on and on and on, and it becomes a major league social problem, a major cause of death. You can't combine alcohol with automobiles, period.
Okay, why don't we haven't got too much time left, so if we can get your closing statements down in about 30 seconds, I suppose, we probably hit it about right. We'll start with you, Dan.
Basically, Dan Poe Newman, I'm running against Michael Morris for Justice of the Peace. This is a race that has been absolutely denied that it exists by the Missoulian, Michael Moore, McElhenney, or whatever his name is. People that I've talked to at Channel 8 and Channel 13 over the past 2 years that I've been running as an announced candidate, over the past 4 years that I've been trying to get some type of reform going in the judicial system and with the attorneys. There's major league problems with the judicial system in Missoula County, and they must be addressed, and they can't be run from, and you can't put a debate opposite this one so that people have to choose between their congressman, finding out about their congressman in a very hotly contested race, and finding out about their JPs for the first time in the case of court number 2.
I'll cut you off here and let David.
All right,
start.
thank you. You know, there's 30 seconds isn't much time to sum up much of anything, but I will just say that there is so much at issue in what happens in court. The court is really the vanguard of all the interests of the government, of the people as represented by the government, of the protection of the rights of individuals as they may be at stake and come before the court and be at issue in any particular case. It's extremely important that, again, this is something that falls squarely upon the shoulders of the judge, and it's extremely important that the absolute independence and integrity of the workings of the court be upheld and protected from any outside interest whatsoever, and it doesn't matter what that source is, private, governmental, or what that is. And that's something that has squarely come to be an issue in this particular race. I feel good about the way that these matters have been handled, and I'm proud of the way that I've at least tried to handle the issues as they come up.
John, will have you?
I guess I have some disagreements with David's last statements. I don't think that they've been handled fairly. I think it's cost the taxpayers somewhere in the neighborhood of $60,000 to try to get these things settled. And to my knowledge, they're still not settled. And I think that I can bring to the court system a even-handed way of working with both courts, so both courts can work together and that those people can work together, so that we don't have the constant bickering and fighting that we have going on right now, and we don't have those situations in the courthouse that David himself has described as being hostile towards his clerks. I think all of that can be smoothed out with some workings with the county and with the people that we have to work with. I think those things can be handled.
I'd like to thank the candidates for being here tonight. We've hopefully presented some information for the voters come Tuesday, November the 8th, and I would like everybody to get out and vote. Don't sit home and be a couch potato. Get out and doesn't make any difference who you vote for, just get out and vote. Thank you very much for watching, and have a good evening.